everyone would look forward to following Clarence Darrow to the podium. And I'm afraid I will inevitably disappoint. One thing that when I arrived, was reminded that we have some of today's material because of Leslie Nielsen's generosity. And I can't recall the name of Larry Nielsen without smiling because of those wonderful comic films that he did, Naked Gun and Airplane and the like. And Chris, our videographer, reminded me of a great Leslie Nielsen scene in Airplane, in which his interlocutor says to him, surely you must be joking. And he responds, I'm not joking, and don't call me Shirley. That's the Leslie Nielsen that I know and love. I'm always a little daunted to try to describe in about a half an hour the result of 20 years work on the nature of the American trial and a couple of books that I wrote out of that. And so it's daunting, but then it's sort of dispiriting to realize I really can do that. I can pretty much sum it up in a half an hour. And that's what I'm going to try to do today. My focus has been on the meaning of the trial's death for us. If the American trial is dying, and I'll tell you why I think that's a fair metaphor, so what? What difference does it make? And what I've been doing is basically appealing to the American public and to the legal profession not to let that happen, not to try to explain it. I think the trial is one of our great cultural achievements, stands in a rich tradition, admired by those people who are closest to it and are in a position to know about it. And Clarence Darrow was, of course, one of the great icons of the possibilities that are embedded in this institution, which is in many ways unique around the world. I think its loss would wound our public culture and certainly our legal culture. Federal Judge William Dwyer out west wrote that the jury trial is the canary in the mine shaft of our democracy. If citizens lose interest and ability to do justice in court, a general loss of democratic governance would follow. If the trial dies, it would not be by a tyrant's axe, but through a long and scarcely noticed process of decay. And I'm going to describe why I think that's a fair description of what is going on here. Indifference in the long run, he writes, is deadlier than any coup, and democratic institutions are easily lost through neglect, followed by decline and then abandonment. As one other judge put it recently, democracy dies behind closed doors. Whether they're the closed doors of a judge's chambers, summarily disposing a case on just written papers, or the closed doors of a government bureaucracy where there's no public participation in the decision, or the closed doors of a corporate office in which important decisions that have impact on the public take place. As one California appellate court put it, participants in secret proceedings quickly lose their perspective, and the quality of the proceedings suffers as a consequence. Popular justice is public justice. So what I want to do today in a short amount of time is four things. One, summarize the evidence of why this is a problem, why the trial is dying in the United States. Remind you much too briefly of what the trial is. Describe our best guesses, and that's all they are at this point, as to why the trial is dying. And enumerate some of the ways in which I believe that this development spells a catastrophe for our public culture. Okay. I'm not a statistician, but I need to describe some of the quantitative data to show that we need to pay attention at this point in our public history. Just a couple of statistics. In 1938, about 20% of federal civil trials, so including antitrust actions, civil rights actions, probably most importantly, went to trial. By 1962, it had declined to 12%. By 2002, the number had sunk to just under 2%. So from 20% of federal cases being disposed at trial to 2% of federal civil cases being disposed at trial. So about a 90% decline in the number of cases that were resolved at trial at all, whether jury trial or by a bench trial. And the rate was accelerating towards the end of that period, down to the point where now there are so few trials, both criminal and civil, that you really can't get any more of a decline. Civil rights cases, because of their personal quality about them, there's a kind of more of a higher level of moral significance to them than in many other cases, fell from 20% of cases going to trial in 1970 to 4% in 2002. So only 1 out of every 25 civil rights trials finds its way to a trial, face-to-face hearing, either before a jury or a judge, in 2002. And again, the numbers continue to edge downward. The percentage of federal criminal cases going to trial fell from about 15% in 1962 to 5% in 2002. So only 1 out of 20 federal criminal cases goes to trial today. One more localized study found that in 1975, twice as many cases were resolved by trial, face-to-face hearing, as by summary judgment. By 2002, 3 times as many cases were resolved by summary judgment as by trial. For the non-lawyers among you, summary judgment is a proceeding in which the court resolves the issue, decides the case, based solely on papers submitted by the lawyers, affidavits, sometimes deposition transcripts, and then purely legal argument. There's never a face-to-face hearing between a party and his representative and a judge or a jury. Number of decisions by our current Supreme Court has made summary judgment, that proceeding, much more likely to occur than occurred before. And more recently, several decisions of the current Supreme Court, 5-4 decisions typically, have made dispositions on motions to dismiss even earlier than summary judgment, before there were even any discovery or any discovery at all. The case can be dismissed at that very first stage, when basically you just have a complaint and an answer. In the new federal courthouse in Boston that was built at great expense a few years ago, there were typically 7 or 8 trials that occurred in each year per courtroom. So they built this wonderful courtroom, spending hundreds of millions of dollars, and basically in each of the courtrooms in that trial, there were only 7 or 8 trials in the entire year in that courtroom. Only about 13 trials per judge, per federal judge per year, down about 67% since the early 60s. State statistics a little harder to come by, but similar developments. Between 1992 and 2001, so a 10-year period, the number of trials in the 75 most populous counties fell 50%, so a 50% decline over a 10-year period. Criminal context, from 1976 to 2002, the percentage of cases tried by a judge or a jury fell over 60% in the state cases. Bench trials and jury trials falling roughly the same amount of time. It was the only part of the legal system that was shrinking. There were more statutes, more regulations, more case law, more lawyers, more than 1 million lawyers, as the song puts it, more judges, and a higher percentage of GDP going to legal matters, just fewer and fewer face-to-face trials, including jury trials. So that's number one. So a statistical picture of what's happening. Number 2 would be what are we losing in this process? It takes a lot of effort to show that what the trial is for us, and that involves basically undoing the results of Law and Order and LA Law and TV dramas. Most of you know from various sources that trials progress from opening statements through direct and cross-examinations in the plaintiff's or prosecution's case in chief, then the defendant's case, direct and cross-examination of witnesses, perhaps exhibits, and then rebuttal cases, the party with the burden of proof, the plaintiff or the prosecution gets to attempt to rebut the evidence presented by the defendant, and finally closing arguments of the sort that you have just heard. It offers a level of deliberation far better and far more demanding and far more rigorous than congressional hearings or press conferences or even the best journalism, where you don't have that point-counterpoint attempt to refute the best case presented by both sides. Enormously more serious considerations of questions of fact and of law or of other normative determinations. The evidentiary requirements of materiality, we say in the law of evidence, that is evidence that is somehow connected with the democratically enacted statute that is the basis of most trials. Testimony that has to be based, as lawyers say, on personal knowledge, that is in the language of perception. What did you see? What did you hear? What did you smell? What did you touch? Not what's your opinion, what's your conclusion, what do you think, what's your best guess, but that kind of very focused, precise, concrete evidence. The rules of the trial require that it be put before the trier of fact, the jury, in that kind of demanding form. And young lawyers have a hard time learning how to present evidence in that way because it's discontinuous with the way we talk in everyday life. The requirements of what trial lawyers call foundations, which all that means is that the question, how do you know what you're about to tell us, has to be answered before the witness then goes on to say what he's going to say. So the jury has some basis to evaluate the basis, the foundation, if you want, for the witness's knowledge. So those basic parliamentary elements of the trial are really important. They keep the trial from looking like the McLaughlin report or to reference one of Northwestern Law School's great graduates, the Jerry Springer show. They're very simple, but very demanding, and they elevate the level of presentation and evaluation of evidence, force it down to the concrete before the kind of arguments that Mr. Darrow just made are made. It's what I call this borrowing from another writer, consciously structured hybrid of different kind of languages in the trial can realize or actualize a usually dormant but extremely powerful common sense to achieve real insights into the persons and events being trialed. Usually that common sense is anesthetized by mass media journalism in many forms, but the trial reactualizes the common sense that actually exists in all of us, and certainly in groups of people taking a serious issue seriously, which is what happens in most jury trials. I've tried to give an account of my own experience as a trial lawyer and what the trial does in well-tried cases where there are good lawyers on both sides. That is a kind of epiphany, a kind of vision as to what is really going on here that occurs in very few other contexts, and that these institutions and practices really allow to emerge from the efforts of good lawyers on both sides of an issue. It allows for the simultaneous grasp of facts, norms, those truths of the heart that Clarence Darrow was talking about, and laws at the same time, and see how they and allows the jury to appreciate how they relate to one another. Not what the law is, but what the law means in this extremely detailed, specific, concrete set of circumstances that all the other devices of the trial brings to the vision of the jury. And I think that allows for an extremely refined grasp of what occurs in a given situation. It surely can go wrong, but in a well-tried case, this actually takes place, and takes place fairly regularly, I think, in American courtrooms. There are moral values, there are common sense moral values intertwined with the narrative structures, the stories. Clarence Darrow was a great storyteller. The stories that lawyers tell in opening statements, and the much more Spartan kind of stories that witnesses are allowed to tell in their direct examinations, where we're required to say just what they did and what they saw. It allows that kind of common sense morality to penetrate through to this very sort of otherwise artificial kind of set of circumstances. So in opening statements, lawyers try to tell the God's eye story of events, what each lawyer thinks the case really means. And the phrase you hear in opening statements in most trials is, "This is a case about," and then the lawyer finishes that story in a way that says, "This is what's really important about this case. Breach of contract, this is a case about a broken promise," for example. So it's connecting up this legal issue to the ordinary sensibilities in the minds and hearts of the jury. The obsessive detail of direct and cross-examination forces us to ask which of those competing stories, those God's eye views, really has more to do with this particular case, the specific case that the jury is actually going to see. That is, those details where we are given to believe both God and the devil dwell, and in which they contend with each other in the course of a trial. So again, it refines and elevates common sense judgment well beyond the anesthetized version of common sense that mass media journalism usually propels us into. Obsessive concern with the factual details of the case, because the details of the case matter in serious cases. So this is an institution that's rooted in our history, political purpose, the ability of our juries to send a message. It allows our juries to send a message to discourage abuses of power. The jury decides what's most important about the case, whether it's about doing justice in the individual case, or as Darrow sometimes argued, the broader political significance of the case and the need to say something to the bureaucratic institutions that within which the law operates. The trial's fierce oppositions that Darrow had really mastered as a trial lawyer is what gives it its power. The differences in role between lawyer and witness, between lawyer and judge, the differences in language, those free, open, no storytelling moments in opening statement, those rigorous kinds of presentations in direct and cross-examination, and then the opportunity to pull it together. Both lawyers have an opportunity to pull it together in closing argument. Those differences in structure of the language allows the jury to get around the issue from all kinds of different perspectives and decide what's most important about the case. And the resolution of the tensions that are involved in those conflicting forms of language and the resolution of those tensions is for us justice, because in our kind of society, it's built up of various kinds of strong tensions in our moral culture. Those different languages reflect those different tensions in, I think, in important ways. A great anthropologist, Clifford Geertz, argued that real insight usually emerges, in his words, from a continuous tacking between the most local of local details and the most global of global structures in a way that bring them both to view simultaneously. And that's what the trial does practically. It moves from extreme detail to broader considerations, political, moral, and sometimes legal. And this came as a surprise to me. I didn't expect to find this institution to be so powerful, and I found it to be that in my participation of trials here in Chicago. I think in the reflective moments, most good trial lawyers value the experience of participating in a practice that astoundingly, in a public practice where power is in play, can actually converge on the practical truth of a given situation. I remember Tom Hanks' speech in Philadelphia describing basically his surprise that the law of the trial especially can basically converge on something that looks like justice. Okay, so why are we losing it? So far, just good guesses as to why this has happened. And explanations of this sort of thing, I think, are dangerous, because explanations almost inevitably lead to, when you say something is caused by something else, a kind of determinism. So this can't be changed because it's the result of very powerful social forces, and you can just sort of give up and let it happen. So explanations you have to hold at arm's length, because you don't want to slip into a mode of thought where you say, well, vast social forces are going to make the trial disappear. There's nothing we can do about it in our legal culture, in our political culture. There are no spaces of freedom. We might as well just give up and admit to a world in which there are bureaucracies and markets, and that's all. We can't allow that to happen as citizens. Okay, so you can look at this. You can look at this either through a microscope or a telescope in deciding what are the likely causes of this development. Okay, so first, microscopically, what are the little changes that have resulted in this dramatic decline in the number of trials? First, there's a change in the culture of judging. And there's been a rise of what's called managerial judges. Judges see themselves as case managers, sometimes muscling settlements, sometimes resolving cases behind closed doors on papers, rather than individuals who preside over this public ritual that is the jury trial. Judges see themselves as problem solvers and multitaskers, and they embrace the dictum that the worst settlement is better than the best trial. In their docket managing, case disposition, to dispose of a case, telling metaphor, they tend to evaluate their performance based on the number of cases closed rather than the number of trials that take place. There's a change. Third, there's a change in the culture of lawyering. There are fewer lawyers with the skills and dispositions necessary to try cases. Trial lawyers have been replaced by litigators, and litigators are folks who are comfortable, and perhaps exclusively comfortable, with resolving cases on paper. So they're paper shufflers rather than the Clarence Darrows of the world. Leads to in civil cases, like civil rights cases, it leads to endless discovery, and so as to avoid ever going to trial, resolving cases by the attrition of who can't afford to engage in this discovery process anymore. Easier summary dispositions, thanks to our Supreme Court. Both summary judgment and even earlier at the motion to dismiss, the preliminary stage. Easier to get rid of cases, dispose of cases, before you ever get to either discovery or a trial. Intensification of the plea bargaining system. And this is a long story. There's a book by a scholar named Fisher called The Triumph of Plea Bargaining that tells the story. Basically, higher proliferation of possible charges, higher minimum and maximum sentences, the ability of prosecutors to engage in charge bargaining. We won't charge you with first-degree murder, we'll charge you with manslaughter if you agreed to plea. So probationable offense as opposed to an offense that brings life in prison. So that basically the prosecution is in a position to make offers that no one can refuse. And that development has reduced the number of cases tried in the criminal context down to 1 out of 20 in both federal and state cases. With the blessing of the Supreme Court, the rise of mandatory arbitration. If you own a computer, you might not know this, but if you have a dispute with the computer company, you have agreed to have that case go to arbitration, where there will be where the repeat players, that is the company, will choose the arbitrators, which will take place in a non-public kind of forum. The economics of the system, skeptical of this because the amount of money that goes into the legal system more broadly. But we are, I think, as a derivative matter, making trials more and more expensive to do. I think that's an effect rather than a cause, but it's a fact of life. Trials are not overly long. 60% of federal civil trials are over in 2 days. 95% are over in 4 to 9 days. So the O.J. Simpson trial, which is pointed out as the icon of why you don't want to have jury trials, is by far the exceptional trial rather than what actually takes place. You can do quite a bit in 2 days of face-to-face hearing. So those are the microscopic reasons. Telescopically, social science, you look draw back and say, what does this development mean in the big picture? Social scientists talk about so-called convergence of modes of social ordering. This close to the University of Chicago, we can use language like that. It eliminates the distinctiveness of different modes of resolving issues. The law becomes more like bureaucratic or market institutions that surround it. Managerial judging, judges muscling settlements, is bureaucratic. The triumph of plea bargaining means that our criminal justice system is almost completely dominated by two bureaucracies: the police bureaucracy, extracting confessions, and the prosecutorial bureaucracy, which is engaged in this offer you can't refuse style of plea bargaining. So the democratic element of traditional American criminal justice disappears and is replaced by two bureaucracies operating in tandem. And the pressure to settle, the enormous pressure to settle in civil cases, to plea in criminal cases, allows the bureaucracy and the market to invade the legal order, and especially the democratic element of the legal order, embedded in the Constitution, the jury trial, both in civil and criminal cases, and squeeze it out of an available means of social ordering in the United States. So what disappears is a distinctive region or place where a citizen can appeal to legal or moral principle, usually through his agent, his diplomat, that is a lawyer who knows how to speak in that kind of rather constrained set of circumstances. And so the big picture is a more bureaucratic, monolithic society where there are fewer countervailing institutions to our corporate and public bureaucracies. I got to think of the transition of the Roman Empire, from the Roman Republic to the Roman Empire, a more imperial, bureaucratic, single-valued kind of society, rather than one with multiple forums with different styles of argument. Another telescopic resolution, and this is deeply cynical, I think it was Thoreau who said the problem with cynics is that they're right so often. That's what makes you mad about them. One possible explanation from a telescopic point of view is the democratizing of the American jury over the last 40 years. Through a series of Supreme Court decisions, earlier Supreme Court decisions, more minorities, women, now serve on juries than was the case 50 years ago. So you have an increasing democratization of the jury pool that would decide jury cases. When the jury was composed solely of people of the same social class, certainly in the federal system that was institutionalized, but even in the state systems, there was less to fear on the part of the elites in our society of the jury trial. Today, there is largely irrational, because juries really don't usually operate this way, an irrational fear on the part of this democratized jury of the institutions of the basically corporate institutions that are trying to steer their cases away from jury trials. The jury trial, the democratized jury trial, invokes common sense, life world norms, discontinuous perhaps with the kinds of norms that prevail in boardrooms and in public bureaucracies. And so there's a conflict there with the sources of the values in which important issues can be resolved. Okay, so what's the meaning? So those are the guesses as to why this has happened. So what does it mean? Now, much more could be said on this, but I'm just going to enumerate a number of what I think will be the consequences of this development. First, we lose a space within which the harshness of judgments based solely on the mechanical applications of rules can be softened by equitable judgments of morality and equity. Remember how Clarence Darrow said, if Haywood is to be hanged, you have to hang him. So it's an appeal to the moral judgment of the individual juror for which the citizen juror takes responsibility. That disappears in a bureaucracy. One writer put it famously, bureaucracies are ruled by nobody. No one takes responsibility for what bureaucracies do, unlike what can occur in a jury trial where the individual jurors take personal responsibility for the judgment that's made. Thomas Green taught at University of Michigan for many years. He wrote a book called Verdict According to Conscience, which is a history of the English jury. And what he argued there was, despite how awful these British criminal trials truly were in the 17th and 18th centuries, at least the fact that they occurred in a face-to-face context reminded everyone that somehow or other this process has something to do with justice. Once you remove the face-to-face nature by which legal issues are resolved, they can become bureaucratic in the bad sense, in which that personal, individual responsibility can disappear. Second, we'd lose a distinctively American forum within which a citizen can tell his own story in public and present evidence to support it, regardless of how implausible it is according to the generally accepted norms of the society. And trial lawyers are basically people who can speak in that public context in a rather artificial sense, but they speak for the person that they represent. We'd lose a forum with the devices to reveal what one writer called brutally elementary factual truth. Just the way it was, and you've got to face it. And that sort of disappears in lots of our public dialogue. This is the way it actually happened. In our public world, in the world of mass media, that's very hard to get to. And what the trial does is allows some access to that brutally elementary factual truth in a particular case. Has tremendous political meaning. Bentham famously said that falsehood is the handmaiden of injustice. Where there are lots of lies, there's probably injustice afoot. You'd lose the experience of citizen participation in self-government. De Tocqueville's famous word, big fan of the American jury, famous words, the jury service scrapes away the rust of private concern that is the bane of market societies, where everyone is pursuing his own self-interest exclusively all the time. Participation in what he called the spirit of magistracy. We have citizen juror has actual responsibility in a real case where really something is really at stake. He's not just a whining critic of what's going on out there, but it has actual personal responsibility in a public manner. It would transfer more and more power, the death of the trial, more and more power to bureaucratic and corporate elites. It would distort further the norms of settlement. There are certain areas of the law where no cases go to trial, and after a number of years, people are just guessing as to what the case is, so as lawyers like to say, what it's worth. It's based on earlier settlements rather than any kind of actual evaluation of the value of cases. Security litigation, in some cases, child support proceedings are viewed to have that quality about them. Killing the trial would eliminate face-to-face drama from the legal system. We would feel and understand less about each case. You lose the dramatic quality that I think and the tensions that it relies upon that show us more about what's really at stake, what the conflicts are within each individual case. It gets us closer, the trial I think gets us closer to what many generations ago people called true law, that is, the real way forward in the individual case. It would render our economic systems more automatic, less moderated or qualified by common sense moral norms. Over the last, we're probably forgetting it already, but over the last 5 years, the American faith in this purely self-regulating market took a serious hit in 2008. There seemed to be a resurrection of the notion that we can't just rely upon these markets to operate on their own power, that we need different forms of regulation, and the jury trial is a form of regulation after the fact. That is, the bringing to bear of non-market norms to individual situations. We live in a more bureaucratized world. Judges would have more raw discretion in the cracks between complex legal rules, which really never really eliminate discretion, because judges can do whatever they want, really. with very few constraints when the law is complicated enough, because there are more decision points for them to go one way or another if they really want to be result-oriented. I think what the trial does is makes it hard for juries to do that, because they're so engaged with the reality of the individual case that's before them, and have more of a motivation to actually do what's right in the individual case, be less willful. 11th, that's what we're at now. More governance would occur behind closed doors. And finally, we'd be deprived of an important source of knowledge about ourselves and key issues of public concern. Darrow's great trials basically illuminated the conflict between capital and labor in a way that newspaper articles never could. And you'd see example after example of that in American history. We'd know less about the effects of asbestos, about cigarettes, and about lead poisoning. It's the existence of trials that really bring, because of the factual specificity that emerges there, that brings us public knowledge of these important issues. And that all is why, more than the memory of Clarence Darrow's great closing arguments, that we as citizens should not allow the American trial to go gentle into that good night. Thank you.